Lateral drains were installed right up to each spring outflow, where it emerged on the surface to capture that outflow. These two had their overlying peat removed, and the evidence suggests that many of the springs were actually excavated to expand their openings and further increase the outflow of groundwater. All of these interventions effectively lowered the spring's natural capacity to limit the release of groundwater into the wetlands. In turn, this increased surface water drainage and flow from the wetlands into the drainage system and to Chile. Madam President, with that overview of the Salalah region, I would now like to take you there virtually. With your permission, Madam President, I kindly direct the Court's attention to a video we have prepared that is a speeded up and shortened version of the one that is attached as Annex 30 to Bolivia's rejoinder. But before beginning, I would like to briefly review the map that we viewed earlier as slide number 2, which you can find in your folder under tab 1.3. The first part of our tour will begin at the eastern edge of the northern or Cajones ravine in Bolivia's Salalah Springs region and follow the ravine towards its confluence with the southern ravine. In the second part of our tour, we will visit the southern or Orientalis ravine, where we will begin at the ravine's eastern edge and follow it all the way to where it merges with the northern ravine. And finally, for the third part of our tour, we will view the main Salalah ravine and move in a southwesterly direction towards the Bolivian-Chilean border. So we begin our tour at the outer edge of the northern ravine. Moving westward, you see the ravine's main canal, which runs approximately 660 meters through the heart of the ravine. You can also see a few darker patches of vegetation, which are remnants of the original Bofedal wetlands struggling to exist in a few spaces where there are no significant secondary or tertiary channels that so effectively drain the Bofedals. Right there, that's good. And as we continue moving down the northern ravine, notice the unnatural straight lines of the canal, and just ahead of us is the point at which the northern ravine merges with the southern ravine, which is the ravine that will now appear on the left side of the screen. Now, this confluence point is also where the main canals of the northern and southern ravine merge to form the principal canal, located in the main Salalah ravine, which flows toward Chile, and this will end the first part of our tour. And for part 2, we will move to the eastern edge of the southern ravine. The first thing we notice is the desiccated remnants of Bofedales that have been severely degraded due to the draining of the area. Looking over the channelized wetlands, you can see the drainage canals that were dug along the outer edge in an oval shape, along with a few secondary canals in the middle. The springs in this area emerge from the fractured aquifer underlying the area and are found throughout the oval. Like in the northern ravine, the darker patches represent areas where the channelized water has escaped the canals and now flows on the surface. But here in the southern ravine, these are areas where inadequate canal maintenance, as well as the movement or removal of the canal stones by visitors and the local population, it has shifted some of the water flow onto the ground surface. Essentially, this is where the wetland is trying to reclaim its lost area. And as we continue down the ravine, notice again the straight lines formed by the canals, as well as the desiccated areas of former Bofedal vegetation alongside the canal. And looking ahead, you can see a group of empty houses. It's set far back from the Salalah waters on the far left side of the screen. And as we get to the midsection of the ravine, you can see the military post, which houses a small group of Bolivian soldiers, and nearby are additional dark patches where the Salalah waters have escaped the channel. Now, continuing with our journey, we now enter a narrow section of the southern ravine, and fairly soon we will reach the confluence I mentioned earlier, where the southern ravine merges with the northern ravine. And this is where we will end part 2 of our tour and begin part 3 at the confluence point of the northern and southern ravine. And just below that confluence point, you can see that old desiltation chamber where until 1997, Chile had an intake that transferred 75 liters per second of water through a pipe some 60 kilometers away to the San Pedro station in Chile. Now, this is also the location of the only intake structure that existed in the early 1900s, and where engineer Robert H. Fox obtained on-site data on flow rates, water chemistry, and other Salalah parameters, which he published in 1922. And I will refer back to engineer Fox a bit later in my presentation. And as we continue moving in a southwesterly direction along the principal canal toward Chile, you can see that the water has gained in momentum and volume. And along the channel, you can see a road that runs the length of this entire ravine. And if you look carefully, you can see the dark lines in that road, which are the remnants of the Chilean pipeline to San Pedro. And finally, as we near the Bolivian-Chilean border, you can see at the top of the screen the blue-colored structure, which is Chile's newer intake mechanism located just across the border. So thank you for your attention to this video. Moving on, Madam President, there is an additional point I wish to make about the drainage infrastructure constructed in Bolivia's territory, which relates to the reason why this extensive drainage system was constructed. Now, Chile argues in its pleadings that the drainage system was installed, quote, for sanitary reasons to inhibit breeding of insects at the Salalah River headwaters and avoid contamination of the potable water supply to Antofagasta, unquote. Essentially, the claim is that by digging an extensive network of canals and channels throughout the Salalah ravine, by excavating the peat layer, by draining the standing water in the wetlands and diverting it into drainage system, and by lowering the groundwater level, you would have fewer flies breeding. Given the extent of the artificial drainage infrastructure that was installed inside of Bolivia's territories, literally thousands of meters of canals, pipes, and drains, it seems incredible to believe that the sole purpose of this colossal undertaking was simply to reduce the production of insect eggs. On the contrary, the main consequence of the extensive drainage system was to enhance the surface flows of the Salalah from Bolivia as they surged toward and into Chile. As early as 1908, in his application for a concession agreement from the Department of Potosi, FCAB's official representative, Mr. Benjamin Calderon, recognized that the Salalah in Bolivia, in its pre-channelized natural condition, did not flow in the manner, rate, or magnitude that met the needs of FCAB. In that application, which was granted as a concession agreement on the basis of its stated needs and purposes, Benjamin Calderon asserted the following: the company that I represent is in need of those waters that are relatively adequate to feed its locomotives that, as is well known, currently use unfit waters that destroy its steam engines in a short time and that must be transported in tanks over large distances, making transportation more difficult. By building intake and channeling works, the previously mentioned springs, the Salalah Springs, could be used even if at increased cost. And the company plans to execute such works to use the waters for its railroad services. Now, a few points must be highlighted from this statement of need. First, note that Mr. Calderon makes absolutely no mention of the poor water quality of the Salalah. In fact, you see the exact opposite, that the FCAB believed that the Salalah waters were of a far higher quality than its then current, quote, unfit, unquote, water source. Thus, the original justification for the channelization of the Salalah in Bolivia and installation of the extensive drainage system was not simply for insect control. Rather, as Mr. Calderon indicated in the concession application, it was to enhance the Salalah's flow so that they could be made usable by FCAB for use in Chile. Furthermore, it is clear that already in 1908, the FCAB had plans to install, quote, channeling works, unquote, in the upper reaches of the Salalah in Bolivia where the springs occurred. Moreover, the company wanted to find a viable alternative to the very difficult transportation of, quote, unfit waters in tanks over large distances, unquote. And finally, the company was willing to build the, quote, intake and channeling works at increased costs, unquote. Now, in its simplest and clearest meaning, the text evidences that in 1908, the Salalah did not flow in the manner, rate, or magnitude that met the needs of FCAB. It also establishes that the company had in 1908 already committed itself to spend considerable resources to modify the Salalah by channelizing the entire water regime in Bolivia's Salalah ravines. Now, this understanding is bolstered by Mr. Calderon's additional assertion in the application for the 1908 concession agreement, where he stated that, quote, it should be noted that the projected work shall make usable waters that are currently being lost, benefiting no one, unquote. Consider this language. It would have been illogical for FCAB to assert that the water was, quote, being lost, benefiting no one, unquote, unless, prior to channelization, some of Bolivia's Salalah water did not flow naturally on the surface and across the border into Chile in a manner that made it exploitable. And it would be equally illogical unless the pre-channelization flow rate and volume of the water that did cross the border was suboptimal. Lastly, I would draw the Court's attention to the fact that 2 decades before the current dispute was submitted to this Court, Chilean Vice Chancellor Mr. Mariano Fernandez acknowledged that the Salalah's flows could not have been used by FCAB absent enhancement through artificial channelization. In May of 1996, Vice Chancellor Fernandez said, quote, it is a ravine from which waters that would be useless if they were not canalized fall, and that have no other use if not canalized. If not, they are lost in bofedales, unquote. In that same interview, the Vice Chancellor said, quote, what was done is to prevent these waters from being lost into wetlands by building rock canals for the water to run in a more organized fashion, unquote. In other words, decades before this dispute emerged, one of Chile's highest representatives publicly recognized that the Salalah of the early 1900s, in its natural state, did not flow in the manner, rate, or magnitude that met the needs of FCAB. Moreover, he conceded that the Salalah's surface flows needed to be, and recognized that it actually had been, artificially enhanced in order to be made usable in Chile. Madam President, as I've provided a general overview of the Salalah and reviewed the artificialization of the Salalah system in Bolivia, I now turn to the impact that this manufactured drainage system has had on the flows of the Salalah. I will first highlight the impact on the surface flows and then discuss the impact on the wetlands. That the Salala's surface flow have been artificially altered is not in dispute. Chile's experts have conceded that the, quote, aim, unquote, of channelization was to, quote, formalize the natural channel system to minimize erosion and to drain standing water, unquote. And that the, quote, constructed channels act as drains and are able to receive water from the wetland soils, unquote. Moreover, they assert that the, quote, channelization of the wetlands and natural Salala River channel in Bolivia is expected to have increased the surface water discharge and decreased the groundwater flow from Bolivia to Chile, unquote. In 2017 and 2018, DHI carried out intensive on-site field investigations on the physical conditions of the Salala. Their studies resulted in an integrated numerical model that very well replicates and depicts those physical conditions. Various factors and model assumptions were then adjusted using best practices in the fields of hydrology, hydrogeology, and numerical modeling to best simulate the conditions that would exist in the Salala without the artificial drainage system. More importantly, the results were then calibrated against real conditions measured on-site in Bolivia's Salala region. So what was the outcome? DHI's model indicate that without the drainage infrastructure, cross-border surface flows would decline by between 11 to 33% of current annual flows. Importantly, that these figures corroborate the measurements provided by Chief Engineer Robert H. Fox, who in 1922, 6 years prior to the start of the channelization of the Salala in Bolivia, published a detailed technical report on the flows and chemical composition in the Salala, as well as on the infrastructure that existed at that time. Fox's records show that the average cross-border flow rates in the pre-channelized Salala were 131 liters per second, 18% lower than the present flow rates, which clearly aligns with the flow rate range of 11 to 33% that DHI's model indicated would result if the drainage system was removed today. Thus, the fact that DHI's model corroborated Chief Engineer Fox's measurements so well and was calibrated against on-site measurements evidences its methodological reliability, integrity, and validity. Today, the Salala no longer presents as a widespread, stagnant, and slow-moving surface flows that spread and meander through dense wetlands. Rather, it has been converted into a fast-moving, channelized watercourse flowing through narrow, artificial canals, channels, and drains. Whereas the natural Salala flows averaged 131 liters per second near the border prior to the installation of the drainage network, DHI studies show that today the Salala's surface flow averaged 160 liters per second. Though I should add that during her opening remark, Chile's agent said that their own measurements indicate an even greater surface flow of 170 liters per second. Regardless, it is clear that the extensive drainage system has substantially increased the surface flows of the Salala as compared to its pre-channelized natural state. The impact of the manufactured drainage network on the Salala, however, was not limited only to its flow regime. It also had a significant and detrimental effect on Bolivia's Salala wetlands. As groundwater levels underlying the wetlands were lowered as a result of the drainage mechanisms, the topsoil in much of the region was desiccated and became salinized. Peat layers dried out and compacted. Natural conditions for indigenous animals and plant life were degraded. Native vegetation was replaced by grasses that required less water and whose longer roots could more easily reach the lowered groundwater levels. And much of the microtopography of Bolivia's wetlands was largely eliminated. That microtopography, such as mounds, ridges, and other surface features typical of bofedales, was responsible for developing widespread pools of stagnant and slow-moving water that are typical of unchannelized Bofedal-type wetlands, characteristics that have now largely disappeared from Bolivia's Salala region. As noted earlier, the Ramsar Convention Secretariat, in a 2018 report assessing the state of the Salala wetlands, observed that over the past century, the land area in Bolivia covered by Salala wetlands had been reduced from 14.12 hectares to a mere 0.6 hectares. It attributed this degradation and desiccation specifically to the extensive drainage system. As the Secretariat noted, quote, "At present, there are only vestiges of the original wetlands," unquote. Surprisingly, Chile challenges this report, asserting that the Ramsar findings are not justified and that they contradict DHI's observations. That there is no need to revisit here Bolivia's substantial refutation of Chile's allegations, which appear in Bolivia's rejoinder. However, it is worth noting that this court has recognized the importance and unique fragility of wetlands designated under the Ramsar Convention. In the certain activities case, the court stated that, quote, "The presence of Ramsar protected sites heightens the risk of significant damage because it denotes that the receiving environment is particularly sensitive," unquote. Thus, deference must be given to a Ramsar designation, and more so to the Secretariat's assessment of those wetlands, in order to ensure that the continued endurance of these distinctive water bodies. Moreover, as a party to the Ramsar Convention, Chile itself is obligated, quote, "to coordinate and support present and future policies and regulations concerning the conservation of wetlands and their flora and fauna," unquote, where such wetlands pertain to a, quote, "water system that is shared by contracting parties," unquote. Accordingly, Chile's challenges to the findings of the Ramsar Secretariat are, at the very least, disappointing. Madam President, as I have described the Salala, it's a fragile water regime that has undergone extensive modification as compared to its natural pre-channelized state, both in terms of its flow rate and the quality of the water that flowed down the artificial canals and channels into Chile. So when we speak about the Salala as an international watercourse that has been artificially enhanced, we mean the following. A watercourse whose cross-border flows were altered in terms of their manner, rate, and magnitude in order to meet the needs of FCAB. A watercourse whose volume of water in its surface flows have been significantly increased by diverting groundwater into those surface flows. And a watercourse whose water quality has been improved over natural conditions by channelization of the Salala wetlands, reducing standing water, and increasing the surface flow of the water through the system. All of this is in a unique, fragile, and complex environment. And this is precisely the situation of the Salala and its enhanced surface flows. So having provided the court with a general overview of the Salala, described the alterations made by FCAB, and highlighted the impact of these alterations on the Salala, I would now draw the court's attention to an additional series of impacts that resulted from the artificial channels and drainage mechanisms. These impacts are the benefits that Chile has derived and continues to receive from the artificial works that are installed in Bolivia. As a result of the more efficient drainage of Bolivia's wetlands, FCAB and Chile have benefited from the enhanced flows that provide more surface flows in the Salala than would have occurred under natural, unchannelized conditions. Additionally, and as FCAB and Chile have also recognized, they benefited from receiving a higher quality of water than they would have received if the Salala had never been modified. Water that was more fit for the company's steam engines and Chile's municipal water supplies, and, of course, also for mining purposes. Lastly, over the past 100 years, Chile has benefited from not having to expend resources on drilling groundwater wells in Chile to obtain the needed water from the aquifers underlying the Salala. Rather, Chile has simply enjoyed the bounty directly from the Salala's enhanced surface flows. And all this is thanks to the significant alterations of the natural conditions of the Salala and its wetlands in Bolivia, the draining of groundwater and the bofedales in Bolivia into the Salala's surface flows, and the transfer of that water across the border to Chile through surface channels. These benefits that I've just described are not insignificant. Capturing surface water comes at a relatively little cost. Capturing the same amount of groundwater, however, can be quite expensive. As my colleagues will explain, these benefits carry with them legal implications that are highly pertinent to this case. Madam President, before concluding, I would like to raise one final, quite critical point. Chile offers an entirely different portrayal of the state of the Salala and the impacts of the drainage system installed in Bolivia than what I have just described to you. Yet it must be said and recognized that Chile's and its experts' strategy is based entirely on attacking scientific reality. They contest and discount the only studies ever made directly on site in Bolivia, those published by Chief Engineer Fox in 1922 and those conducted by DHI more recently. Their own assessments of the Salala's flows and of the entire Salala hydrologic regime are based on remote and off-site investigations, as they never set foot in Bolivia, where the Salala originates in springs and where the artificial drainage system was installed. And in the words of Chile's own experts, their analyses are based on, quote, highly simplified, unquote, and, quote, elementary, unquote, calculations, and that their analysis was, quote, never intended nor used to produce Chile's own estimate of the expected effect of the channelization, unquote. This simplistic, remote, and conjectural approach, however, is quite surprising and stands in stark contrast to the realities in the field. In its own pleadings, Chile has confirmed, quote, the complex nature of the Salala River and the groundwater flow systems. And its experts have recognized, quote, that the hydrogeology of the Salala system is complex and difficult to understand from the limited data available, unquote. As a result, Chile's simplified and elementary interpretations, estimations, and hypotheses are inadequate to deal with the complex hydrological properties and spatial variability of the Salala regime, and thus have only marginal value for this case. Madam President, Your Excellencies, as I said at the start of my presentation, the chief point that I wanted to convey to the Court is that the Salala cannot be described purely as a natural international watercourse. The Salala is presently and has been for nearly 100 years a unique and international watercourse with artificially enhanced surface flows. The surface flows of the Salala are and have been for the past century artificially enhanced, not by a few small acequias, but rather by an extensive network of 6.5 kilometers of canals, channels, pipes, and drains. This is evident simply by viewing the images I shared with you, but also from the substantial enhancement made to the Salala's cross-border surface flow and water quality. And it is also evident from the significant artificially created benefits that Chile has taken advantage of for nearly 100 years and continues to enjoy today. And it is evident from the extensive degradation and desiccation that the drainage system has wrought on Bolivia's distinct Salala region and its fragile Ramsar-designated wetlands. With this, Madam President, distinguished judges, I thank you for your time and attention, and I kindly request that you please invite Professor Matthias Forteau to the podium. Thank you.
I thank Professor Eckstein, and I now give the floor to the next speaker, Professor Matthias Forteau. You have the floor, Professor.
Thank you very much, Madam President. Madam President, distinguished members of the Court, I am greatly honoured to appear before you to defend the rights and interests of the plurinational state of Bolivia in this case. My task today is to delimit the scope of the dispute that has been submitted unilaterally to you by Chile. Pursuant to Rule 60 of the Rules of Court, the oral pleadings shall focus on the issues that still divide the parties. This provision is not always strictly complied with by the representatives of the parties, but in the instant case, it warrants particular attention insofar as the scope of this case has been very greatly reduced, and that there is a very large number of points on which the parties agree, as both Bolivia and Chile have noted in their written submissions, and as did Chile once again last Friday. In its rejoinder, Bolivia had already attempted to identify the points of agreement, those which required further clarification and those which remained open, and it had stressed that if due clarifications were provided by Chile, and in particular if the latter consequently amended its final conclusions, this might bring the parties yet closer together and thereby eliminate any remaining points of disagreement between them. I wish to emphasize in that respect that Bolivia's rejoinder was submitted almost 3 years ago, and that this was the last time it expressed its views in writing. Needless to say, since then, Bolivia and its councils and experts have continued in good faith to assess the points at issue in this case, having regard in particular to material provided in the meantime by Chile and expert reports which have been filed. Chile, for its part, claimed the right to file new written submissions at a later stage, in which it deemed it useful to submit new scientific data, which puts into perspective Mr. Wordsworth's essential
matter. Les écritures du Chili ainsi que ses plaidoiries de vendredi ont montré un peu plus encore non seulement que les éléments d'accord entre les parties étaient considérables, mais aussi et en définitive que l'essentiel de la demande du Chili est très largement sans objet. Dans la mesure où le règlement judiciaire n'est qu'un succédané au règlement direct et amiable entre les parties, il importe de commencer par identifier ces points d'accord pour mieux déterminer ensuite quelle doit être l'issue de la présente instance. Cela suppose toutefois au préalable de revenir sur l'origine et la nature des réclamations du Chili, car cela permet de mieux comprendre pourquoi le champ du différend se trouve très substantiellement réduit. Le 6 juin 2016, les autorités de l'époque du Chili ont décidé de saisir la Cour par voie de requête unilatérale.
The court by way of unilateral application. This was a sovereign choice which belonged entirely to the Chilean state, but whose advisability can seriously be called into question, and that for several reasons. It should first of all be recalled that contrary to the impression which Chile attempted to make in the long passages of its memorial on the origins of the dispute, as well as in the incomplete presentation of this on Friday, the dispute did not arise abruptly in a diplomatic note of Bolivia dated 3rd of September 1999. Firstly, this diplomatic note notably followed a previous diplomatic note by Chile dated the 20th of May 1999, in which the latter objected to what had been said within the Bolivian parliament regarding the waters of the Salala River. Secondly, Chile now no longer dwells on the fact, and it was far more talkative about this matter in its application, that in the diplomatic notes sent by its authorities in 1999 and to which Bolivia was duty-bound to respond, Chile had felt the need to intervene in matters which fell within the remit of Bolivian domestic law. Yet, as Bolivia's note of the 3rd of September 1999 rightly stressed, Chile nonetheless did not have any legal interest in intervening as such in what constituted a dispute under domestic law between Bolivia and a private firm. This dispute concerned the termination in 1997 and the renewed award 2 years later of a concession contract with regard to the waters and installations of the Salala River in Bolivia, a concession contract to which Chile wasn't a party. In September 1999, Chile challenged the terms of the bid for tenders issued by the Bolivian authorities with a view to concluding a new concession contract. Again, on the 14th of October 1999, Chile expressed reservations regarding the tendering process and on the 3rd of December 1999 even requested for it to be suspended, implying that without such a suspension, it would not be possible to hold any dialogue between the two states regarding the Salala River. On the 27th of April 2000, Chile also objected to the contract entered into by Bolivia with a DUTEC firm, as it considered that this contract was void. These interferences by Chile in a domestic contractual process give cause for concern in more ways than one. To start, it should be pointed out that at no time did the termination and the renewed granting of the concession contract prevent Chile from using the waters of the Salala River flowing in its territory, nor indeed infringe its effective enjoyment of its international rights with regard to these waters. Nothing besides that infringes these today either. Besides, Chile has never claimed the contrary before you. On the very contrary, Mrs. Klein-Kannenberg on Friday stated that despite the annulment of the concession contract in 1997, Chile has continued using the waters of the Salala River, waters which, and I quote Mrs. Klein-Kannenberg, have been used in Chile, and I quote, since 1910 and as of today, end of quote, and this has been completely unhindered. Next, it is worth noting that this concession contract was a contract under domestic law entered into by the Bolivian authorities with regard to the waters and the installations of the Salala River located in its own territory, and matters pertaining to this contract therefore fell under Bolivian domestic legal order, as the terms of the relevant documents clearly showed. Besides, a few years beforehand, Chile had acknowledged that the measures taken by Bolivia vis-à-vis licensees operating in its own territory fell within Bolivia's responsibility. In 1996, Bolivia was concerned in a press communiqué that Chile was the only one to benefit from the use of the installations on the Salala River without any compensation whatsoever being paid for the use of the installations constructed in Bolivian territory and exploited by private licensees. This press release of the 7th of May 1996 had not been contested by Chile in any way at the time. Quite the contrary, 3 weeks later, the Chilean Vice-Chancellor declared very firmly that everything which pertained to the concession contract regarding the Salala River and the corresponding financial claims did not concern Chile in any way, and moreover noted in passing, as was said earlier on, that according to him the waters of the Salala would be lost and would be useless if they were not canalized, which Chile is now contesting. Likewise, in 1997, when the concession which had previously been granted to the FCAB was revoked by the Bolivian state, Chile pointed out that this revocation was purely a contractual matter and could not give rise to a dispute between the two states at an international level. Moreover, Chile also acknowledged in its reply that the concession is a sovereign act of the Bolivian state regulated by Bolivian domestic law and that all matters pertaining to it shall fall within the private sphere. Chile even declared on Friday that Bolivia had correctly stated in 1999 that this was a matter falling exclusively under domestic private law. This stands in sharp contrast to the position expressed by Chile in 1999. In any event, it is worth stressing that since 2003, namely 13 years before the matter was brought before the court, there is no longer a single concession in force in Bolivia in respect of the waters of the Salala River, and there was absolutely nothing in the management of the concession contract which could have warranted bringing the matter before you 13 years later in 2016. In its memorial, Chile refocused its claims on the only relevant issues that pertaining to public international law. But a reading of these claims shows that they are, in fact, limited in scope, if they have any purpose at all. These are limited first and foremost with regard to their purpose. According to Chile, it petitioned the court not in order to ask it to settle a dispute regarding a situation giving rise to any conflict on the spot. The aim of its application, and I quote Chile's words, was solely to put an end to an undesirable situation, to unnecessary tension, and a situation of legal uncertainty. At no point in time in its written submissions or during the first round of its pleadings did Chile explain to the court what actual effects it's expecting from the court's judgment as regards the situation on the ground. And this is at the very least problematic in view of the court's function, which is not to reassure states in cases of uncertainty, but to settle concrete disputes. Likewise, unlike what the Chilean agent asserted on Friday, the role of the court is not to find, and I quote, opportunities to confirm certain basic principles of international law. The role of the court is not to legislate in abstract terms, but to settle disputes. The examination of the very essence of Chile's claims leads to make two additional findings. Not only Chile itself acknowledges that the dispute is limited in nature, but especially it acknowledges that its claims are exclusively declaratory in nature. Chile is solely asking the court, and I quote, for a series of declaratory orders. Even its liability claim, which is totally untenable, is again purely of a declaratory nature. Chile is seeking no reparation, no compensation. In short, is not making any claim for redress of any kind, and quite rightly, because Bolivia has never committed the slightest violation of international law with regard to the Salala River, as Mr. Bundy will demonstrate. The court will quite legitimately ask itself why Chile decided to refer a case to it with all the ensuing costs to make mere declaratory claims solely in order to dispel, to quote its own words, an uncertainty. The question is all the more legitimate in that Chile is not complaining about any actual measure which Bolivia may have taken to its detriment. Chile, in fact, is not denying that Bolivia has never, and I stress never, taken the least measure which may have blocked, hindered, or prevented in any way the flow of the waters of the Salala River in Chilean territory, nor has ever taken any measure of any kind which might have prevented the Chilean state from using these waters in accordance with international law. Likewise, Chile has never claimed that Bolivia ever took measures in the field which might have interfered with the quality of the waters of the Salala. To this day, Chile continues, as was already the case when it petitioned the court, to make unhindered use of the waters of the Salala flowing through its territory, and it has never complained about any pollution or any other harm which would have been caused to its waters. In paragraph 52 of its application, Chile admittedly reserved, and I quote, its right to request the court to indicate provisional measures should Bolivia engage in any conduct that may have an adverse effect on Chile's current utilization of the waters of the Salala River. However, not only Chile has never deemed it necessary to avail itself of this reservation, which confirms that none of its actual interests have ever been infringed. But again, the very way in which this reservation is worded shows quite clearly that the subject matter of the Chilean application is primarily hypothetical in nature. The passage of the application, which I have quoted, states in a manner which is in several ways conditional, and I quote, should Bolivia engage in any conduct that may have an adverse effect on Chile's current utilization of the waters of the Salala River. End of quote. This wording quite clearly amounts to acknowledging that the effective use by Chile of these waters has never been harmed or prevented by Bolivia. Admittedly, the Bolivian authorities have sometimes made declarations which reflected a difference of points of view between the two states as regards the precise nature of the waters of the Salala River. Some of these declarations may well have been expressed in strong terms, but that is the very nature of certain political speeches, in particular in a very delicate context in which the two states were otherwise at odds at that time regarding the issue of the sovereign access to the sea. In the context of the latter case, I would also like to note in passing that Chile has been particularly keen to put weight of words into perspective by trying to deny the legal significance of political statements. According to Chile, it should not legal weight should be given to political declarations with a view to leaving states with the necessary diplomatic space to explore possibilities for resolving the matters that divide them. In this case, Chile has considerably reduced this diplomatic space, which is conducive to a friendly settlement, by instituting in a hasty and unilateral way proceedings before the court on the mere pretext that Bolivia had expressed views with which it disagreed. 3 additional remarks should be made as regards Chile's hasty petitioning of the court. First of all, Chile seems to have brought a case before the court primarily for preventive purposes as a response to an announcement made by Bolivia that it gave itself at least 2 years to consider bringing possible legal proceedings with respect to the waters of the Salala River. It's doubtful that this is an appropriate reason to refer a case to the court. The announcement made by the Bolivian Minister of Foreign Affairs in April 2016 that Bolivia would not bring legal proceedings before 2 years at the very least constituted in actual fact a clear signal, albeit implicit, that Bolivia was open to dialogue and to diplomacy. This announcement echoed the declaration made by the president of Bolivia a few weeks beforehand, according to which Bolivia didn't want any more confrontations, any more disagreements, and it also echoed an invitation which was publicly sent to the president of Chile to come to visit the Salala River. Nothing in the case file seems to indicate that Chile ever replied to this invitation. Its only reaction was to lodge a unilateral application with the court. Secondly, Chile's attitude is all the more problematic in that, as Bolivia explained in detail in its submissions, in 2000, the two states had launched a mutually agreed process to better determine together the nature, the origin and the flow of the waters of the Silala River, including the additional flow generated by artificial installations. That showed that there was an agreement between the two states that such a study was necessary. Chile expressly recognized that it was necessary to examine the precise nature of the waters of the Silala in greater detail, which proves that nothing straightforward nor clear-cut seems to appear in Chile's position as it contends now, and that it would have been advisable to continue its studies, as Bolivia emphasized in its rejoinder. In its memorial, Chile indicated that it had always been in favor of such joint studies, but this assertion is not consistent with its hasty referral of the matter to the court. And I add that at regular intervals during the years prior to the referral of the case to the court, Bolivia has reasserted that it is open to dialogue, and I repeat, it has never taken any measure to the detriment of Chile.
Thirdly, as indicated in Bolivia's readings, both parties back in June 2008 decided to begin discussions on the conclusion of agreement on the utilization of the waters of the Silala River, which led to a first consensual text in July of that same year, 2008. My colleagues will be coming back to the actual content of that draft agreement later. At this stage, I will simply make two comments. One, the content of this draft agreement shows that the status quo was deemed to be unsatisfactory and that an agreement was considered necessary by both parties to clarify the rights of the utilization of this Silala waters. This led in particular, in the draft agreement, to the acknowledgement by Chile that in certain circumstances it would have to pay compensation to Bolivia for the utilization of these waters. Second, Chile put an end to the discussions on the draft agreement on the grounds that Bolivia had claimed compensation for past utilizations of the waters of the Silala, which Chile contended would have radically changed the terms of the conversations to the point of making them impossible to pursue. This calls for two comments. It confirms, a contrario, that the other elements of the draft agreement were still acceptable to both parties, and this contention also does not reflect the facts, given that, unlike what Chile contended, the October 2020 meeting during which Bolivia made this claim ended in agreement from both parties to pursue the discussions and not, as Chile now states, to put an abrupt end to them. Chile, moreover, made an abusive claim, or several abusive claims, during the 2010 meeting. After Chile had expressed its objection to the call for compensation for past utilizations of the Silala River, Bolivia told it that in that case it would reserve, and I quote, its right to use Bolivian-free available waters by using them in its territory or by reconstituting the natural conditions of the area of the Silala Springs, end of quote, which was perfectly entitled to do. Chile, however, considered this approach was not compatible with the purposes of the discussions. Back in 2002 already, Chile had opposed to any change to the flow of the waters, which was tantamount to refusing Bolivia's right to dismantle the canals. This is in contrast with the position expressed since Chile's reply, including Friday's oral arguments, in which Chile does acknowledge that Bolivia does indeed have a right to dismantle. Be this as it may, Bolivia asked Chile to resume the discussions on 2 occasions, in the summer of 2011 and the spring of 2012. Chile never responded to either of these 2 invitations. It also ignored them in its written pleadings and during its first round of pleadings. Right up to its application introducing proceedings, Chile remained opposed to any discussion at a political level with Bolivia. Chile chose instead to seize the court unilaterally, without delay, as it said, at the risk of aggravating tensions between the 2 states, although, and I repeat it, at no point in time did Bolivia take any measures to prevent or hinder the utilization of the waters of the Silala, or which would have produced in any way their flow or quality. Madam President, the agent of Chile asked Friday, why are we still here before the court? Well, with due respect, the relevant question is rather, why are we even here in the first place? The agent of Chile strongly emphasized the need for cooperation. She even argued, as a new justification for her country's litigation before the court, that this unilateral legal action was needed to provide, and I quote, an opportunity to develop strategies of cooperation, end of quote. But, distinguished members of the court, unilateral judicial action, legal action, is surely not the best way to encourage international cooperation and good neighbourliness. Admittedly, exchanges during the instant case have led to the settlement of a number of matters still in abeyance, but this would certainly have been possible in a less costly, more consensual and more efficient fashion without the pressure of proceedings before the court. Its workload would have been lightened if Chile had not seized it unilaterally and prematurely. Madam President, before I move on to the points of agreement between the parties, perhaps this is a good moment to take an afternoon break. I leave it up to you to decide, of course.
Thank you, Professor Forteau. It is indeed a good time for the coffee break, so the court will adjourn now for a period of 10 minutes.